Afternoon, everybody, and welcome to the Law Research Centre of Dublin City University. My name is Federico Fabbrini. I am the full professor of law at DCU and the director of the Law Research Centre. And it is my great pleasure to open and chair this first event of 2023 of the Law Research Centre on digital constitutionalism towards a progressive actification. I would like to begin by warmly thanking my colleague Edoardo Celeste, who is Assistant Professor of Law, Innovation and Technology at DCU, and who also assists me in directing the Law Research Centre this year while I am on sabbatical at Princeton University. And of course, I would like to warmly congratulate him for the publication of his first monograph entitled Digital Constitutionalism, the role of Internet Bills of Rights, which has just been published open access by Routledge in the UK. In the current academic year, the Law Research Centre has decided to dedicate a large part of its activities to presentation of books published by our staff. This is both to showcase the research work that is being produced at DCU Law, but also to build bridges with scholars and practitioners in other institutions. With its strong focus on European and international legal and interdisciplinary research, in fact, the Law Research Centre is designed to be the natural interlocutor in Ireland on cutting-edge legal and policy matters that profoundly affect our European Union. From this point of view, Edoardo's book is an ideal case. Its focus is on the emergence of international Internet Bill of Rights. The book is based on Edoardo's PhD dissertation, and I shall also mention and applaud Edoardo for being the PI of an Erasmus Mundus Master in the Law and Artificial Intelligence, a master called Emil Dai, which just kicked off at DCU this academic year and is fully funded by the European Union Erasmus Plus program. So this conversation could not be more timely and topical, and we are really fortunate that four prominent scholars and practitioners from across Europe have accepted to join us this afternoon to discuss Edoardo's book. I will briefly introduce our speakers, and there will be plenty of time to hear from them later on today. So the panelists will be going in the order in which they are listed on the program. Elizabeth Farris, who is Assistant Professor of Law at University College Dublin and the Director of the UCD Centre for Digital Policy. You're very welcome, Liz. Our second speaker is Clara Iglesias Keller, who was until recently a fellow at the Wissenschaftszentrum in Berlin, but very recently took over as research group lead on technology, power, and domination at the Weizenbaum Institute, also on Berlin. Clara, you're very welcome to join us too. Then the third speaker will be Vagelis Papakonstantinou, who is a professor of law at the Vrije Universiteit in Brussels, at the Free University of Brussels, where he's also the chair in personal data protection and a well-known expert in the field of digital constitutionalism. And finally, last but not least, we will hear from Colin Rooney, who is a partner at Arthur Cox, one of the leading Irish law firm, where he leads the practice in technology and innovation. And Colin is a longstanding friend of DCU, the Law Research Centre, and previously also the Brexit Institute, which Arthur Cox for long supported over the years. So I want to welcome Vagelis and Colin also to our debate this afternoon. Before handing over to our speakers, I want, however, to call in first and foremost Edoardo, who we are celebrating today for the publication of his book. He's really the man of the day for all practical purposes. He will begin by outlining the content of his recent publication and then fleshing out some questions that will shape the conversation in the next 1 hour, 20 minutes. Before doing so, let me remind everybody that we are recording this session so as to make it available later on the Law Research Centre website. So it's a great pleasure to see almost, or actually more than 60 people connecting to this book launch and discussion. Without further ado, Edoardo, I hand over to you.
Thank you so much indeed, Federico, for this introduction. Let me thank you again for allowing me to host this inaugural webinar of the year 2023 of the DCU Law Research Centre, and to thank all the speakers who have accepted my invitation, but also all the friends and colleagues who are taking the time today to attend this online webinar of the DCU Law Research Centre. So you said that I will be the man of the day, but in reality, at least from the first few sort of like conversation that we had in the meeting room before starting the meeting, I had the impression that my speakers have several questions and comments on my book. So I'm really delighted. I hope that this will be also sort of like a learning experience for me, and a discussion opportunity actually for all of us who are interested in this cutting edge topic at the intersection between law and new technologies. So I'll give you sort of like a very short introduction about the monograph that I just published. But before doing this, I would like also to mention that this webinar actually is run in collaboration with the Law and Tech Research Cluster of the DCU Law Research Centre, in collaboration with the discussion group of the Digital Constitutionalism network that is also run in partnership with the Humboldt Institute for Internet and Society of Berlin. And last but certainly not least, in partnership with the European Master in Law, Data and Artificial Intelligence, the new Erasmus Mundus Master that you, Federico, mentioned in the introduction. So I would like to start with a very brief, by providing you with a very brief overview about the sort of like the content, maybe like the key sort of like messages and lessons, if you want, of my monograph. So you rightly said this is based on my PhD work that I've conducted at University College Dublin, which has been funded by the Irish Research Council, a work that actually started at least in its sort of like ideal part already several years ago. And indeed, it was a particular event that prompted my research in this field. And it's very interesting to see that actually these kind of events are repeating in their forms and size today. So the event that I'm actually referring to was that in 2014, 2015, the Italian Chamber of Deputies created an ad hoc committee to draft a declaration for internet rights and principles. And this episode actually pushed me to start a research in this field. And it's very interesting actually to notice that today, sort of like various years later, we can observe how even at the European level, in December 2022, so a few weeks ago, a new declaration on digital rights and principles for the European Union has been adopted. So a topic that, if you want, has not faded in terms of like its relevance over the years. So I was particularly interested in this initiative of the Italian Chamber of Deputies of setting up a commission to draft a declaration for internet rights and principles. And then, starting my research in this field, I discovered that actually this initiative was not isolated at all, that there were multiple, if not many, declarations of rights and principles for the digital society. And this is why I started actually collecting a data set of documents that, by using a denomination that was already in use by scholars from various disciplines, I called Internet Bills of Rights. So of course, I mean, this is a denomination that can be sort of like discussed, but I think that it well gives the idea of the type of document that we are dealing with. So as you may imagine, Internet Bills of Rights are not legally binding declarations. So most of them are actually documents proposed by civil society actors, even if they emerge in the setting of international organizations, actually they don't have a legally binding value. So given the size of this phenomenon, because when collecting this text, I actually counted more than 200 of this text, and then for the purpose of writing the book, I actually focused on a smaller data set of 40 documents. My main question was, what is actually the sort of like the sense of this phenomenon? Why are these texts emerging? What is the message, especially from a constitutional perspective of this phenomenon of the emergence of internet bills of rights? So essentially, my book is composed of sort of like two parts. There is a part with the results of an empirical research on these sort of like smaller data sets of around 40 documents of internet bills of rights, where I tried actually to address the question of like, what is the message? What is the added value that these documents comprehensively regarded and observed are sort of like transmitting or are trying to convey on the sort of like in the constitutional environment. And in the first part, I actually tried to set the scene by proposing a sort of like a theory, if you want, that might justify the role of these internet bills of rights from a constitutional point of view. And this is directly related to the topic of digital constitutionalism, from which actually this webinar also takes the name. Just like in a nutshell, if you want just to reconstruct this theoretical framework, of course, the starting point of my research is to argue that the constitutional environment is not something set in stone. So sometimes we have this idea of our constitutional norms as being sort of like documents inherited from founding fathers in the past that cannot be modified. But in reality, of course, it's in the nature of constitutions to progressively change and actually to adapt themselves to react actually to the challenges of the society where we live. And of course, one of the major transformations that we are witnessing today is the digital revolution. However, what is interesting is that the constitutional environment is itself reacting to this revolution. And of course, it's not reacting only in a sort of like traditional way. So we may immediately think that of, for example, constitutional amendments, so new constitutional provisions or decisions of Supreme Courts and so on. But in reality, we live in a society that is so complex that constitutional counteractions, I argue in the book, also emerge at other sort of like constitutional levels. So they might emerge, and this might be interesting to discuss actually in the second part of this webinar, at the level of ordinary legislation. They might emerge in sort of like regulations and directives adopted at European level or in other regional settings. Or they might even emerge beyond the state. And this is where actually I locate a position, if you want, the emergence of internet bills of rights, sort of like a source of constitutionalization that would emerge beyond the state. But what is interesting to notice, and this is another sort of like of the main points that I make in the first part of the book, is that if the constitutional counteractions that are emerging are fragmented on the one end, because of course they emerge at various levels, on the other end, it's possible actually to reconstruct or to have a sort of like an idea of the mosaic, if you want, that is progressively emerging from a constitutional perspective. And this is why actually I speak of multi-level constitutionalization. So this idea that this process of emergence or rearticulation, if you want, of constitutional norms is currently occurring at multiple levels that actually are complementing each other, that they are nourishing each other, so that they cannot be taken actually in abstract isolation as in separate silos. And to conclude that then the sort of like the first part of the book, I therefore explain, because to me there was a certain confusion in the scholarship, the difference between constitutionalization, which I intended as a process of sort of like emergence, rearticulation of constitutional principles for the digital society, a concept that is different from the one of digital constitutionalism, that would rather be the ideology, if you want, or the strand of contemporary constitutionalism that is trying to address the issues of the digital revolution and is pushing actually to rearticulate the ideals and values, the DNA, if you want, of contemporary constitutionalism in light of the challenges of the digital society. And just to conclude, in the second part of my book, what I do is I propose an empirical analysis of internet bills of rights. And I argue that actually this type of research might be particularly interesting because it's telling us, first of all, what are the areas that are currently in need of intervention. So by looking at what are the provisions that these declarations of rights are actually proposing, we can understand what are the areas of constitutional law, if you want, that are perceived to be in major need of intervention. So one of the arguments that I sort of like make and that I stretch along the book is actually to say that constitutional provisions more broadly might be very nicely sort of like crafted and drafted, but they might not be able to speak anymore to the digital society. So maybe they speak to legal practitioners. This is actually a topic that I would like to discuss with you later. They might speak to legal practitioners. They might speak to sort of like judges, lawyers, but can they be understood by the actors that are playing a major role in our digital society? Hence the need of rearticulating principles also through sort of like civil society and non-legally binding declarations. Secondly, I look at the sort of like personal, if you want, scope of application of these internet bills of rights, arguing that, of course, the dichotomy between state and citizens is completely overtaken in these instruments. We do have businesses, corporations that play a dominant role, a very incisive role on the sort of like constitutional plane in the digital society. And these actors are directly addressed by these norms. And lastly, in the last part of the book, I actually focus on the sort of like message that is conveyed through these instruments. It has been particularly tricky actually to recompose an image of what all these instruments want to say, because they might have a sort of like a different focus. But I think that generally speaking, we can distinguish sort of like norms, constitutional values and principles that are simply reiterated in the context of the digital society, other principles that are rearticulated. So there is a sort of like an intellectual exercise that is made actually to readdress, reformulate these principles to better address the challenges of the digital society. And finally, there are also new sort of like what I argue are new kind of like norms or principles, if you want. So new rights as well that are progressively sort of like developing, and that they target specific sort of like challenges that are uniquely generated by the society where we are living. So this is in a nutshell the sort of like the content of my book, but I'm sure that I will have the opportunity also to add other points and highlight other points while we are discussing this issue. But let me just finish by making the link with the sort of like the topic of today's webinar, because I thought that this research might well actually sort of like complement one of the trends that we are currently sort of like observing, especially at EU level, which is this phenomenon of actification. So we are witnessing the emergence of a series of legal instruments at EU level that bear the name of AXA, which is somehow something unusual, at least at European level. And I would like to discuss why this is happening with my colleagues, but particularly sort of like overall questions that I have for our speakers are sort of like, is this sort of like trend sort of like meaning that we are witnessing a progressive process of constitutionalization of new principles? So are these acts called in this way because they are particularly important from a legal perspective, and they are proposing new principles of constitutional nature, if you want? And also, like, another question that I would have is, what is the direction that we are taking with all these various different pieces of legislation? What is the sort of like the message that globally taking are these text documents, very important documents, conveying? And also your personal perspective of whether this is in line with the instruments, the bills of rights for the internet that we have, of which we have witnessed the emergence so far. So I'll stop here. I would like then to sort of like open the conversation for our speaker. So I'll hand over then to Federico, who will sort of like ask the individual speaker then to make a reaction statement to this. Thank you so much.
Thank you, Edoardo. And again, I would like to commend to everybody Edoardo's book, which is also freely available online, open access. That's, I think, very much in tune with the spirit of digital constitutionalism in many ways. So it's there for everybody to be read. And thanks, Edoardo, for fleshing out the structure, the content, and the big ideas behind this. I think there will be now plenty of opportunities to zoom in and discuss several of the innovative contributions you make in your book. So if you agree, I'll go with the list in the same order as they are in the program. So without further ado, I'll call on Liz to break the ice. And as we said, 5-7 minutes so that we can make this a little bit more interactive. So Liz, the floor is yours.
I thank Federico for your introduction, and to Edoardo for inviting me to be here today. And congratulations, Edoardo, on your excellent book. I'm lucky to start this conversation with some very high-level concerns and developing principles, which I'd like to tie into the discussions in Edoardo's book, and also to this question of actification. And I'm going to bring to this conversation my perspective, first as the former director of what you could broadly call tech advocacy programs within a lateral network of domestic NGOs from around the world, from 15 domestic CSOs, one of which is the Irish Council for Civil Liberties, which is located here in Ireland. So that would be sort of my first location informing my perspective. And then my second location would be my role as the director of the recently established academic UCD Center for Digital Policy, which seeks to build digital policy capabilities for the benefit of everyone. So we also look at policy concerns, and we do that. We certainly have an eye on what's happening at the EU, but we really try to focus on those who have been vulnerabilized or made vulnerable by both new technologies and the social conditions and the infrastructures around them. And so my perspective here today, I think, brings to the fore three things. First, we're seeing a lag between social problems created by disruptive tech and the deployment of legal mechanisms and solutions, including legislation. And Edoardo has laid some of that out in his book. And then there's, I would say, a disconnect through, and if I may use the term, actification between developed or developing legislation and the social problems that the legislation is targeting. And I don't restrict this discussion to the EU. I look at domestic examples. And then finally, just talking about the space for fundamental rights in this milieu. Like, what do enshrined rights, which were established long before the development of the internet, what do they mean for us today? And what are the barriers to upholding them and to responding to new principles that are emerging around them? So when we think about lags, there's a well-established lag between the emergence of social problems created in new digital spaces and legal mechanisms for prevention. We have examples like cybersecurity, online harms, hateful rhetoric, digitized sexual abuse, amplification of offline harms and consequences, personal data protection. 10 years ago, harms weren't established in the literature, but we're seeing those harms begin to be thoroughly documented across the experiences of different interest groups. The more complicated question is, how do we handle this? And in the context of this lag, I just wanted to note that NGOs have really been deploying creative solutions that sometimes operate quietly in parallel the legislative machinery they advocate for as instruments of accountability to governments. And human rights technologists have been talking about the problems with tech for years, for decades now. Like, human rights technologists, they're security professionals with human rights orientations, often found working at NGOs, working to defend rights. And so they'll work in parallel, doing things like knowledge exchanges, security exchanges. Human rights technologists working in Egypt will learn systems to avoid unlawful surveillance techniques, software, behavioral changes, and they'll quietly go to other NGOs in other countries and share that knowledge. So there is this lag in response, and then there are these quiet parallel activities that happen alongside the advocacy for new laws and new acts. And even when we see acts emerging and we see a suite of new legislation at the EU level, the GDPR, Digital Services Act, Digital Markets Act, the AI Act, the AI Liability Directive, we see this suite of new legislation coming out, but the evidentiary question before academics is, how suited are these laws, some only recently enforced, to manage the social problems they're responding to? AI legislation, are the categories of risk the appropriate way to, respond, for example, to police decisions to deploy facial recognition technology en masse to domestic populations, despite proven evidence of bias and discrimination against historically vulnerable populations? Image-based sexual abuse and the question of intent, and problems of scale. How does legislation manage that? And then there's the problem of enforcing that existing regulation too. Should we bring out more regulation every time something new arises, or can we refer to existing acts? And how do we help local authorities deploy the existing acts to novel circumstances? There's a real capacity problem in Ireland for the data protection authority. And then third, there's the question of fundamental rights and the social justice for the communities impacted by these technologies. So we have these rights, these long-standing rights to privacy, to protest, to talk about what's important to us. And I really appreciated Edoardo raising in his book the question of translation. How do we translate these long existing rights in the new digital space? What new rights they're developing that have been uniquely generated? How do we prompt sluggish rights mechanisms like the United Nations to sort of catch up with the issues that are happening? And on that note, I would note that, again, human rights organizations have been pushing for a new general comment under Article 17 of the International Covenant on Civil and Political Rights. We observe that the right to privacy in the digital age is completely changed since the committee's publication in 1988 of that general comment. We need updated infrastructures that respond to the lags and the disconnect, and that adequately translate digital rights in our new digital age. And I think that's my time, so I'll stop there and I'll hand it back over.
Thank you very much, Liz, for those inspiring and very thought-provoking comments. Without further ado, I'll hand over to Clara for her remarks. And then, as I said, there will be chances for questions and discussions at the end. Clara, the floor is yours.
Thank you so much. Well, first, good afternoon to everyone. And thank you so much for the invitation, Professor Fabrini, Professor Edoardo Celeste. And it's the last time I refer to you as Professor Edoardo Celeste, I promise. I'm delighted to be here with this very interesting and excellent colleagues to exchange on Europe's recent regulatory trends, an interest that we clearly share. But I also see this, if I may, Professor Fabrini, as an opportunity to celebrate Edoardo's book and his work. So Edoardo is a reference on the scholarship on digital technology and the law, especially with regard to this concept of digital constitutionalism. So this expression is very much associated with the codification processes that we talk about today. I have recently had the opportunity to publish my understanding of this association together with my constitutional law professor, Janie Hayes. And she and I proposed a rather critical approach to this labeling of recent regulation as digital constitutionalism. The thing is that I currently see a conceptual inconsistency that, specifically with regard to the regulatory debates, might end up doing a disservice to the idea of mitigating private powers, private platform powers, or even powers, which is one of the ideas very much embedded in constitutions. So as an independent term, and Edoardo has gone through these meanings, and so I'm not going to spend so much time on that. But as a term itself, digital constitutionalism has been used to refer to different things. So as Edoardo mentioned, a set of documents of different origins that share a constitutional language in common, and thus seeks to strengthen or even impose the protection of constitutional rights online. We have here so many important colleagues that have written about this, also in our audience, Dennis Hadeker, Claudia Padovani. So that's the approach they gave to digital constitutionalism. In other works, it appears as a certain reconfiguration of constitutional protections, a phenomenon where constitutional law embraces the digital agenda. Edoardo has addressed that. So as in the past, we thought of environmental constitutionalism and economic constitutionalism, now we think of a digital one. And in a different sense, and in my opinion, by far the most problematic one, digital constitutionalism refigures as a theoretical frame for different possible means to regulate digital platforms. So we see reference in the literature to institutional arrangements that are purely self-regulatory, like the Oversight Board, for instance, to state-led regulation, like the codification we talk about here today, and more specifically the DSA. So Edoardo addresses this conceptual inconsistency in his work, and he will correct me if I'm wrong, and I apologize in advance. But he solves this by framing digital constitutionalism as a certain ideology, which I agree with. And I also propose that we go further into this inconsistency critique to say that when we label these different initiatives without nuance, all of them end up borrowing from the epistemic value of constitutions and of constitutionalism without necessarily delivering its results in terms of legitimacy. So the Constitution is not a metaphor. That's what I mean to say here. And expanding this use to legitimize private power risks its historical and normative meaning. So this is a critique that I think is relevant for digital constitutionalism, but also to what I call its theoretical matrix. That is a whole set of theories that reflect a broader debate about functions and means for the enforcement of the law in complex, globalized private environments. This includes, for instance, global administrative law, the post-regulatory states of Colin Scott, and in the level of constitutionalism, global, societal, and multi-level constitutionalism, as Edoardo mentioned as well. And I'd be happy to talk more about these theoretical debates, but not to go so much out of my 5 minutes. I'm going to drop into the legislation. To say that I think that this theoretical debate also somehow relates to the regulatory one, where we also see this inconsistency taking place to some degree. So we already see in the literature the critiques that the type of mechanism that we have proposed, even within state-led legislation like the DSA, might be tending to legitimize platform power, private platform power, rather than mitigating it. So for instance, Natalie Hellberg has a paper on misinformation, a 2020 paper, where she already nods to the fact that when we see this big powerful company doing content moderation, for instance, and we say, look, you are very powerful, so you need to be transparent, or you need to observe the process, we're in fact legitimizing this big, powerful structure and giving them duties rather than actually trying to mitigate them. So maybe, perhaps, I don't know, we can see a connection here in the expansion of constitutionalism as what I see is perhaps a misuse in some specific cases, and the current turn that this process of actification has taken. I'll just end by saying that I think problematically wise, we have, it's this last sort of use that ends up encompassing regulatory strategies that are very different between themselves. But that's all I have to say for now. And thank you so much once again for having me. I'm really happy to be here.
And thank you, Clara, for your comments. And let me, of course, echo your kind words to Edoardo. That's indeed the day where we are marking the publication of his book. But let me move straight to the next speaker in our panel, Professor Vangelis Papakonstantinou from the Vrije Universiteit in Brussels, who will be the next.
Thank you very much, dear Federico. Thank you very much, Edoardo, for your kind invitation. I am very happy to be here, not only because the launch of a new book and the finalization of the PhD process, as I understand it, is a happy occasion always, but also because I have discovered an academic soulmate in Edoardo, because apparently his academic interests coincide very much with my own this period of time. And this relates not only to actification, but also to digital constitutionalism, which, however, I will approach from a different perspective. But let me please first start with actification. Actification, to my mind at least, is a research noted trend, relatively recent since 2019, or something that has started at EU level to release eponymous, so to say, pieces of regulation instead of anonymous in the sense of alphanumeric that were released in the past, in order specifically to regulate digital technology. So this is not a generalized trend for all new pieces of legislation by the EU, not even all new regulations released by the EU, but indeed a very specific, to my eyes at least, trend by the EU to release easily identifiable and easily referenceable by Europeans pieces of legislation to regulate specifically digital technologies, apparently on account of their horizontal effect to the lives of all Europeans, therefore better to be regulated at EU level as per also the principle of subsidiarity, but also, again, to my mind, in revealing a newfound confidence by the EU to be recognized itself as the direct legislator for large parts of European lives that no longer have to be harmonized at a member state level, therefore Europeans refer to their national laws. But from now on, once all these instruments come into effect, Europeans will be able to refer directly to EU acts. Some of them, like the DMI, also to be implemented at EU level. So this signifies perhaps an important switch in the way we do things in Europe. And I think it is a noteworthy phenomenon. As regards the second part, the digital constitutionalism part, again, I share the academic interest with Edoardo, and it was with extreme interest that I read his book, because I too am concerned about the effect of digital technologies on the law. However, whereas Edoardo has taken a turn in dealing with the effect of the law of digital technologies on the law through digital constitutionalism, myself, I have been trying in the past few months or years to develop a new state theory, so to say, and within the context of states as platforms. And let me please use a couple of minutes to explain what I mean by that. I have discovered that because of the information age, we have to go back to the basics. And I claim that first and foremost, states, in a sense of organized societies, have always been for their subjects or citizens information brokers. In the sense that immediately, whenever anybody was born, he or she was given a name and a nationality. Without them, any person is inconceivable in human societies, not contemporary nation states, but also empires of the past, city-states, the Roman Empire, Iron Age empires. At all times, whenever anybody was born, he or she was given co-created information by the state. And then the state had two very specific and very important tasks that took precedence before on any other: to preserve this information and to authoritatively transmit it to third parties. Therefore, if I have a name, I need the state to authoritatively say that I am Vangelis and not Edoardo, and vice versa. Same with the nationality. And then when I wish to transact with somebody else, I needed again the state to authoritatively say that it is me, Vangelis, who is transacting with Edoardo and enter this transaction. Otherwise, again, human life would be conceivable. And from this point of view, this takes precedence over both Leviathan's security reason of creating a state, because the state needs to know who to protect, and also before social contract theories, because again, if you wish to start a social contract, you need to know the contracting parties. So already the state has participated in attributing the second contracting party, the individual. Therefore, however, I claim that this role of information broker or information platform in modern terms of the state has been kept low over the past of the ages, because everybody transacted locally. Because at all times through human history, even until the 80s, when I was a kid, so I'm revealing the age, but it's okay, we transacted locally. Whenever we wanted a book, to buy a book, we went to the local bookstore. Whenever we wanted to buy music, we went to the local music record store. Whenever we wanted to see a movie, we went to rent something from the local video store. And whenever we wanted to buy even software, back in the 80s when they merged, we went to the local software store selling out of the shelf software packages. So everything was done locally. And here comes the connection with Edoardo's work, and I think chapter 10, but throughout his book, this completely was broken with the internet and digital technologies, because immediately the direct relationship of the state and the individual was broken. And Edoardo also mentioned it in his introduction today. So I'm glad that this is a central understanding of his book, because I also share this finding. So the necessary relationship of the state and the individual was broken, and the door was open for others to come in. By now, we all know that if we transact, we can transact internationally without the state even knowing, bypassing essentially the state. So the state that in the past, either under a Leviathan approach or whatever else, could maintain its authority in practice because it was on top and controlling all information flows within its territory, has now seen its role challenged, and now has to interact with other actors. So the beyond the state approach that Edoardo discussed in his introduction, multi-level constitutionalism, you name it. There are those approaches on that. The fact remains that many actors have entered where the state was the only plain alone actor in the field. So because this role has broken, I think that a new role for the state needs to be developed and be found. And but again, and I'm concluding with this, I may, but maybe I have misread the book. I would not go towards cosmopolitan constitutionalism and multi-dimensional and co-creation of rules for individuals residing in any state, nation state of today. So to this, maybe I differ with the approach of the book. I would try to find the new role of the state within its constitutional boundaries of today. So translate what is old into the new digital reality, but still remain within the same boundaries. So thank you very much, both for your patience for me theorizing so much. Thank you.
And thank you, Vagelis, for touching on the issue of the role of the state, sovereignty, transformation in public authority over the centuries. That I think was extremely helpful. But let me now move to our last but definitely not least of the speakers this afternoon, our good friend and colleague, Colin Rooney from Arthur Cox. Colin, it's a pleasure to have you back at DCU Law, and the floor is yours.
Thank you very much. Thank you. So first of all, good afternoon, everybody. Thanks to Federico, thanks to Edoardo, thank you to the DCU Law Research Centre for the invitation to speak at today's, or on today's webinar, I should say. I might open by saying my perspective is very much that of a practitioner. I don't have the same level of expertise. I'm certainly not a scholar as Federico was introducing various different speakers, and I don't have maybe as much to say on the digital constitutional side as the speakers who have so ably and clearly expressed their views before me. My perspective is really around advising on technology law and to a greater extent on data protection law over the last sort of 15 or so years. And in that time, I've particularly over the last, say, 2 to 3 years, I've seen a lot of new initiatives coming very, very quickly. And I think in general, those initiatives they're welcome. And by initiatives, I mean statutory initiatives coming from, or legislative initiatives coming from, particularly from the EU. I think it's definitely clear that the pandemic has accelerated those initiatives, and the initiatives, I think, we see the EU setting the pace. And in addition to heartily endorsing Edoardo's book, which as a non-academic I found very readable, I have to say, I'd also say I found Vagelis' article particularly informative in terms of thinking about what I was going to say for this particular segment. And one thing which really struck me is I think the EU is now setting the pace, sort of rightly or wrongly. And I say rightly because I think that means we have perhaps a more harmonized approach in terms of what happens and the laws that are being introduced. But it also means you are working with a one-size-fits-all system. And I'll talk a little bit more what I mean by that in a moment. My perspective in advising usually client companies, some international, some domestic, has sort of informed a point of view which is that this can be sometimes a very positive thing, but sometimes it can be a somewhat confusing thing. I was struck by 3 things in particular coming out of Edoardo's book. The first thing is, he makes a very valid point, which I think will be unsurprising to the audience in terms of legal systems and in particular constitutional systems being faced with the challenge of operating in a very much an analog way, or an analog world. I think we've had that problem, and certainly throughout my entire career I've seen that in terms of technology. The legal system that we operate in doesn't necessarily move anyway as quickly or as dynamically or as flexibly as the area that it is operating in or it is seeking to regulate. Secondly, there's undoubtedly a greater complexity in terms of the actors that are operating. Certainly, I'd go back to the point which has just been made by Vagelis in terms of the role of the state. I think obviously the role of the state is important, and it occupies several different roles in several different ways. Again, large platforms have a particularly important role to play, and I think they're considering constitutional matters not at a nation state net level necessarily, but across several different economic blocks, never mind countries. So I think that's a factor as well. And I think the third factor, which was really came out of the book for me, was in relation to the opportunities that are afforded individuals by digital technology, their capacity and ability to exercise their rights. And I see that a lot in terms of GDPR. What's interesting for me coming out of that is that I see certain GDPR rights exercised far, far, far more frequently than others. So, for example, every single day I advise on data subject access requests, yet I advise very infrequently on deletion requests or, objections and that kind of thing. So I think it does, those rights are available, but the degree to which the rights are actually exercised can differ enormously across society. And I think that's kind of interesting in a context where there is a whole range of new laws. Those laws are helped certainly by having, I think, a clearer title. And to go back again to a point alluded to by Vigalis, having a number is not necessarily as informative as having a title, and that title, artificial intelligence, the meaning. However, I think the challenge there is how you knit all those pieces of legislation together, particularly in circumstances where they have been introduced, as I've said, in a very short period of time, and the manner in which they speak to each other is not entirely clear, or at least is not entirely clear to those to whom the laws are often directed. The second point I would make is, I think often these laws are based to a certain extent, or use the GDPR as a blueprint or a framework in terms of how they're prepared. They have certain characters or certain players who are given certain responsibilities, and then there's certain rights associated or obligations associated with those players. Think data controller, processor, and then apply those different concepts in terms of the AI Act, or indeed the Data Act, and you see this play out. But again, the GDPR is really at this stage only beginning to be bedded down. We're seeing the enforcement has accelerated, and there's lots of things you can say about enforcement by the GDPR, but there has been, I think, an acceleration of that over the last 12 months. So it does take some time even for that piece of legislation to take effect. And I think it'll be interesting to see what the interaction is like then, with several new pieces of significant legislation coming in a very short time frame. And maybe the last comment I'll make is just in relation to the interaction between different legal systems. So again, coming at this very much from a practical practitioner's perspective, often with these types of legislation, and particularly when the Commission pushes the legislation and it's coming at a kind of centralized way, sometimes, particularly for a common law jurisdiction like Ireland, that can be quite challenging in terms of the practicality of principles which can look very civil law based, which can seem to be very much around codes and codification. And our system, as everybody in this webinar will be aware, is very different. And at a practical level, it can be very different. And I'll just throw, as by way of my final comment, one example. When there were some new rules introduced in relation to standard contractual clauses for international data transfers, we had to make a very quick amendment to our law to allow for certain rules around third-party beneficiary rights, because our rules on privity of contract are quite different to what would have been seen in continental Europe. So I think the idea of this sort of push towards a more unified, comprehensive mechanism whereby laws are kind of introduced at a commission level, and there's less, I suppose, scope for the member state to necessarily to implement, and it's more of a harmonized approach, is welcome in many regards, and I suspect it would be welcome to a lot of the large players, despite what you might think. But there are problems in terms of when the rubber hits the road and the practical application of those laws. So I'll just finish on that point and say thank you very much again for the invitation. And again, I'll just finish by heartily endorsing Edoardo and his new book as well.
And thank you very much, Colin, also for bringing in a practitioner perspective to this conversation. I think that was exactly the intelligent design of this panel, having international speakers from multiple member states, including academics and people who deal with this issue either from an NGO or a legal practice perspective. So there is really a lot of food for thought, I think, out there. And I think it's only fair for me to hand back to Edoardo, who deserves an opportunity to answer some of the questions and comments that have been raised by the previous speakers, after which I will open up also for questions from the audience, and then again give opportunity to the panelists to interact one with each other. But Edoardo, I think now you should come in again and try to answer some of the suggestions you received.
Yes, thank you so much, Federico, and thanks to all the my colleagues and friends actually who have sort of like provided their perspective on the book and on the broader issue of actification in the EU, specifically in the digital field. I found actually all your comments and the different perspectives extremely interesting, and I would like also to save time for the Q&A that we have planned for the last half an hour of the event, but let me pick only like a few sort of like points that you raised that I consider particularly interesting, starting from Liz, who rightly highlighted the role of translation of principles. So this is something that I mentioned very quickly in my introduction. In the book, I refer essentially to Gunther Taubner's systems theory that essentially advocate the sort of like re-articulation of constitutional principles in order to address the challenges of the digital revolution. So in sort of like in very simple words, what I argue in the book is that sometimes we lawyers, we tend to say we do have rights, we do have principles for the digital age, but in very often actually we can understand them, but the actors that are playing a very important role in the digital society sometimes have difficulties actually to implement them. And I'm sure that you might have in mind what is currently ongoing, for example, in the field of like social media, where we have companies that, objectively speaking, yes, they're sort of like pursuing their own kind of like business objectives, but on the other hand, they also do not have sort of like a clear, uniform sort of like a guidelines on how to moderate content, on how to manage, for example, speech and the users on their platforms. I also appreciated Clara's comments that highlighted actually the complexity of defining the concept of digital constitutionalism. Absolutely, the book doesn't aim to provide sort of like the final word on the definition of this concept, and as Clara highlighted, it brings in sort of like various proposals, especially referring to the previous scholarship. So I'm really delighted also to see that Clara has recently published this further contribution to the field, and here also in the audience I see so many colleagues who have been contributing to sort of like foster our knowledge in the field of digital constitutionalism. I definitely think that, I mean, all perspectives are welcome, even if I personally agree with Clara's points on reducing the concept of digital constitutionalism to the limitation of power of private platforms is certainly reductive. Thanks, Vagelis, actually, for identifying me as your academic soulmate. I do also think so, especially in light of your last contributions on actification. We didn't have the time, but you also discuss with our colleague Paul Deert the concept of GDPR mimesis, which I also found extremely interesting, and probably I don't know if we will have the time to discuss it.
Sorry, I have to. But Colin said about this when he said his second point, the GDPR blueprint, was exactly that. This was I was smiling at that point because we did not speak with Colin beforehand. We had not planned this, but he referred his second point was GDPR mimesis.
Exactly, which is indeed, I mean, just to put it in simple words, this attempt of using the GDPR, as Colin said, as a sort of like blueprint, as a model for other types of regulations. And this is what can be partially seen in the current trends of emergence of new acts at European level. And Colin, I think that you highlighted a point which is extremely interesting when you made the example of Ireland, for instance, struggling in some circumstances to incorporate values and principles that are proposed from a continental law perspective. I think this also highlights one of the issues that is at the basis this broad discussion on digital constitutionalism, which is the one of the diversity of values and principles. Just to also to address one of the points made by Vagelis earlier, the book doesn't argue in favor of a sort of like uniform cosmopolitan constitutionalism. This is not the purpose of the book, but the purpose of the book is rather to highlight how there is currently a conversation on which rights and principles we should adopt, also to reflect the existent diversity of views and values that exist, and not only between nations, but also among the various societal sectors that are most impacted. I'll stop here, Federico, because I'm keen to hear the comments and questions from the audience. So thank you so much again to all our panelists.
Thank you, Edoardo. So I'm happy to open up for questions or comments from the audience. I think after 2.5 years of pandemic Zooming, more or less everyone knows how this works. So you're very welcome to raise your virtual hand. And then Lucrezia Rossi, the project coordinator of the Law Research Centre, will be able to unmute you so that you can ask a question. And maybe turn your camera on so we can easily identify. Or I shall say, alternatively, if for whatever reason you're not able to speak, feel free to insert your question in the chat so that I can then read out for the panelist. Let's see if anybody is interested in jumping in. And maybe just to break the ice, oh, I see Emiliano, you probably wanted to come in. Can we unmute Emiliano? There you go.
I find it like very interesting. I think you all agree in the fact that we are going through some kind of constitutional moment. This expression Edoardo uses, and I think you can all agree upon that. But I wanted to know what your insights out about the legitimacy of this constitutional moment. I mean, the literature on how constitutions should be made is wide and profound, and it usually involves some kind of popular participation, citizens' participation. We actually had some examples here in Ireland, in Europe, in Iceland, and in many other countries. It's usually passed by referendum. So there is a great discussion on how constitutions should be made, and it usually involves some kind of popular participation. But I don't find this citizens' involvement in this process. I'm sure if I stop someone in the street and I ask him or her if we are going through a constitutional change, he will probably say, no, what are you talking about? So citizens are not really engaged in this process. And the very legitimacy of constitutions derives from popular legitimacy. So what are your thoughts about the process of constitutional change and its legitimacy, of course?
Thank you, Emiliano, for that question. Let me see if we can collect maybe another question so that there's even more. Okay, I see a question coming from Loyola Houghton. With the speed of development of new technology, the chat GPT going through 3 rounds of development in a short timeline, is it feasible to create policy which move at this quick of a speed? Also, how do you ensure that as we develop this constitution quickly, we have coherences across the European Union? So I think is 2 questions which somehow are related. One is about legitimacy, one is about coherence. So I saw you, Clara, were eager to come in. So maybe I'll start from you there.
Thank you so much, Federico. I actually, Emiliano, want to tell you that I don't think we're living a constitutional moment. I'm trying to find the nicest, softest way to say that, but I don't think we're living a constitutional moment. Indeed, it bothers me that we now use the word constitutional as an adjective and we throw it around. We have a constitutional moment, we have a constitutional environment. And I just think that this collaborates to what I call this epistemic crisis of the concept of a constitution and constitutionalism, right? So I also see the legitimacy problem that you pointed out. And I think this is one that we can relate to what I call the theoretical matrix of digital constitutionalism. So, but this is something that the very authors of these theories, they address, right? And Edoardo knows the work of Gunther Teubner well better than I do, but correct me if I'm wrong, Edoardo, as far as I know, like Teubner, he nods at this limitation. He says, indeed, we're talking about some sort of like constitutional structure that does not hold popular participation, but it is what it is. It doesn't really like offer anything more than that, right? We do have multi-stakeholder and other sorts of theories that try to hang this legitimacy not on participation specifically, but on procedure or on results, right? I happen to have written a paper about that called Democratic Legitimacy in Global Platform Governance. And I merely borrow from, me and my co-author, we merely borrow from a theory of Vivian Schmidt that builds on Sharpe's theory for the European Union that talks about input, throughput, different sorts of legitimacy. And the one thing that I find is that indeed we do not invest enough on what is input legitimacy, right? On which is like the original idea of democratic legitimacy. So I think that it's a problem, as you pointed out, but I also think that maybe it's not that much because we're trying to call constitutionalization things that are not really constitutionalization. When we talk about, oh, the Facebook Oversight Board, it's not a constitutional solution, it's self-regulation, in my opinion, even though we try, oh, it does relate to an attempt to have a second instance. And yes, it does, but it's not constitutionalization. At least in my opinion, it doesn't seem so. And on a meta level, just to end this answer, I do wonder myself if this resource to constitutionalization is also to constitutions, to constitutionalism. I'm not going to say constitutionalization anymore because Edoardo already pointed out there are different things. But this resource to the idea of a constitution, of a constitutionalism, isn't that a sign of a democratic and even regulatory crisis, right? Like now that we said there was no regulation, we said regulation did not work out. So now let's call it constitutionalism. Let's call it a constitution. Maybe now it'll work out. And I think we end up calling the same things or even different things, but that are in the same strain, constitutionalization, in the hope that we'll fill up this legitimacy meaning, but this is a meta comment, not so much based on theoretical or empirical findings. And that's all for now.
Thank you, Clara. I wonder whether Liz, Vagelis, or Colin also have something to add on this. And I don't want to put anybody under the spotlight unless they wish so. Vagelis.
First of all, I really appreciate Clara's insistence on gatekeeping the words and the meaning of the words. I very much am in favor of this, speaking exactly about using the exact word. So I very much appreciate it. Having said that, I do believe that we are not through a constitutional moment, but even if we were, so just to entertain this possibility, please keep in mind that all the event today is about digital technologies. It's not about the analog world or the real world around us or whatever, brick and mortar world. It's about digital technology. So if, which I very much doubt, but if we are going through a constitutional moment, then we are going through a constitutional moment in digital technologies. And then if we are going through a constitutional moment, digital technologies, then I revert the question to you, who is the digital people to whom this constitution is addressed? Have we in some way created a constituted European people or something that this constitution would be addressed to? So I'll finish with that because Clara, I think, addressed Emiliano's question quite well and extensively. Regarding the other question, and this is a very popular idea that I would like to object to immediately, the law does not need to keep up with technology. So I never tire of saying that. It is not our job, considering that we are lawyers in this webinar, it is not our job to keep up with engineers. We may try to accommodate their needs and pace of development and I don't know, working environment and new ideas. We may do this, but we may also choose not to do this. This is not a task of the law to keep up, first. And second, not everything that is suggested as new is really new. So this is time and again evidenced once new technologies have matured and settled down. And because this has been proven time and again, we do not need to devise new legislative tools each time a new technology is produced. We can very well accommodate the new technology through already existing regulatory tools, which we have done through copyright for computer programs, etc., etc. So we do not need to keep up with all of that. And as regards coherence, yes, it is a prerequisite, but we're still in an intermediate stage. Indeed, the Commission has released a tsunami of new regulatory instruments regulating digital technologies, and somehow these, at the end of the day, have to interact once they are all in effect, because each one of these initiatives is in different stages of the lawmaking process. They will need to interact, but this will come in the future, so we will have to give them some time. So, thanks.
Thank you, Vangelis. Liz or Colin, I think Liz, probably you were unmuting yourself, so maybe you want to come in.
Yeah, thank you. I think I would also defer to Clara with respect to the first question, and thank you, Clara, for letting me know that Meta's oversight board is not a constitutional space. I guess, does that mean it's not a Supreme Court either then? It's not a parallel judicial enforcement activity. I mean, with respect to the second question, that's a really important question. And it really brings to the fore what we look at the Digital Policy Centre. You know, is it not our job to respond to technology? Is that the question, or is it really, again, as human rights technologists have been saying for decades, is it sort of a task that's beyond the law, not just because of, you know, is there an adequate set of legislation or laws on the books, but are there enforcement capabilities and infrastructures around that existing legislation, and are there, like, you know, even like adequate ideological perspectives on when a law is being broken or not? There's just a lot of questions that have built up around existing legislative infrastructures that remain unanswered. And what we are seeing people do is trying to adapt what, you know, so Colin Scott is you know, the dean of the School of Social Sciences at UCD, and he's a member of the advisory board with the UCD Centre for Digital Policy, and he's attempting to develop what he would call sort of a regulatory toolkit at the EU level that sort of brings in questions that didn't exist before, like how do we make evidence-based policy now compared to how we would develop that 20 years ago? I mean, we didn't have like regulatory sandbox trials for new technologies 20 years being deployed like they are now. Are those the appropriate evidence-based peaks that we should have at new technologies before looking how legal frameworks should be wrapped around them? It's hard to say, like, how do we respond to ChatGPT in an academic setting? It's hard to know. And like copyright, you had mentioned, Vangelis, and like copyright, I spent some time wondering, could I use copyright as a mechanism to respond to problems of revenge porn, to respond to problems of image-based sexual abuse? Because that seemed at the time, through Van Bauer, an academic in the US, that seemed like a way to take an existing law and repurpose it for new technology. Spoiler alert, you can't do it, you can't make it work, but it's just, there's a lot of questions. And I think at the end of that convoluted statement, I wouldn't know how to answer that question, Loya. Like, there are still so many questions. There's a suite of legislation that's come out. We're going to have to sit back and see what that new legislation can do and how it responds to new technology.
Thank you, Liz. Colin, do you want to jump in too?
Yeah, just very briefly. I won't address the first question. I think Clara has very comprehensively responded on that one. Just in terms of the new law and the idea that maybe new laws might chase new technological developments. I mean, I think Liz has put it very well, and I wouldn't necessarily depart very much from what she said. I think from my experience, I think it's a mistake to have legislation in particular chase technological developments. I think we've gotten a lot better at this over the last number of years. Technology should be drafted, or legislation should be drafted in a way that's technology neutral. And I think if you can attempt to do that, often you find, as Begalis has very well put it, that the sort of same issues are coming up, perhaps in a slightly different way, but they're coming up as time passes. So, what was cloud maybe a few years ago was something else before that, and it just that maybe the terminology changes, but the underlying technology is not all that different than something which has come before. Where I do think it is a requirement that the law, though, is responsive is in relation to case law, particularly the common law jurisdiction. We need the cases to feed through and to give, I think, some degree of precedental value. And secondly, we need regulatory guidance. And that's, I think, something which organizations, clients in our case, or indeed individuals or data subjects, as I often see in the context of my practice, do need, and that I think can be almost more important than new legislation or in particular new statutes chasing new technological developments, which, as I've said, aren't often all that new.
Thank you very much, Colin, for that. We still have time. Edoardo, before handing back to you, I was trying to see if we can collect maybe one or two more questions, so we have then a final wrap up in the last 10 minutes. So if anybody else has a question, please seize the moment and the opportunity. And maybe I'll abuse my position and ask a question myself, if you don't mind, Edoardo. That's suppose a question for you, but for the other panelists as well. I mean, as a professor of EU law, something that comes to my mind is the following. Number one, isn't the sort of the trend towards actification a simple revelation of the fact that the EU has no power except lawmaking? The EU doesn't have an army, doesn't have even particularly strong financial resources, but we're really very good at drafting laws. And so we try to deal, when a new problem comes up in Europe, you just draft a regulation or a directive, you use the lawmaking power to deal with it. And connected to this, the use of the word acts, maybe because I'm at Princeton now, isn't it the attempt by the EU to present itself as, a new United States type of regulatory authority, instead of using long regulation names with numbers who nobody's remember, you say it's the AI Act. That sounds like a lot more the Patriot Act or the No Child Left Behind Act, of which we have gotten use in US jargon. So there is this dual dynamic, isn't it, where you use the law because basically you don't have other instruments in the EU, and then you use the terminology of the act because it makes it look as more powerful, and I think easier to remember and associate with, particularly for the citizenry. So maybe what I'll do, and sorry again for abusing my position, I don't know if anyone else, Clara, you were raising your hand. Was that a question you wanted to put for the other panelists?
Yeah, I remember we spoke when we were having a little chat that I had so many questions for Edoardo, and I don't want to overburden him, but maybe also my other colleagues can weigh in on this. And I am very interested in how rights evolve, not only interacting with technology, but other social, political factors and etc. And one of the uses of constitutionalism, as Edoardo mentioned, and I said beforehand as well, is this idea that the constitutional agenda adapts to a certain new paradigm, to a certain set of new or renewed concerns, and then tries to embrace that and put it and give it a constitutional protection, let's say. And I would like, and then we would talk perhaps about new rights or rights that look new, but they derive from something that already existed. So I would ask Edoardo and my colleagues if they get this feeling out of the legislation that is being enacted in these last years by the EU. If you see, for instance, if you would have examples of a new approach to freedom of expression or a new approach to privacy beyond data protection, if you actually see like new rights and the actual adaptation of protections, of legal and constitutional protections to this new paradigm, do you think everything is just being updated, or do you feel like there's an evolution here of the rights that we need in order to defend ourselves and even be ourselves in a digital society? Does this make any sense? Okay, thanks.
Thank you, Clara. Thank you. That's very helpful. Listen, what I propose we do is that we take the speakers in reverse order so that Edoardo can be the last. I think he deserves the last word to conclude within 10 minutes. So if that's fine for you, Colin, I'll call you first to share any additional thought, potentially address Clara's question or other things you want to bring up.
No, my final thought would just be to say thank you again for the invitation to speak. I found it a very interesting, thought-provoking webinar, I have to say. Again, I think I'm fascinated by the road ahead in relation to I suppose the sheer level of new law that's coming through. I'm not sure if we are in a constitutional crisis. I think we might be in I wouldn't say a regulatory crisis, but we're certainly in a position where the regulatory environment in which we are operating in is changing very quickly, very substantially. And I think it is changing in a way which means that for all of the players, it's going to be challenging to be responsive to that and to be responsive to that in a meaningful way. My own preference would be if some of the law came in a more gradual fashion, and there was one act followed by another act followed by another act rather than things coming in really all around the same time. But other than that, just to say, found it very thought-provoking, and thanks again for the invitation.
And thank you, Colin, for bringing in, I think, what is a key perspective in this conversation, the perspective of somebody who works with the law rather than just sort of analyzing it or commenting it and see it also play out in practice. So thanks for being with us. I'll hand it back now to Vangelis for his comments.
Okay, thank you. Let me start by what Paul said about the practitioner's point of view, and I very much agree, and I think that it will get even harder because until now, traditionally, practitioners were in one way or another isolated within their own jurisdiction. This model has broken down through the GDPR. It will continue, it will be shattered at the end of the day. So technology lawyers will unavoidably have to study their own jurisdiction, so case law and law material from Ireland or wherever they're located, but also whatever decision comes out in Italy or Germany or France may affect them, and even directly because of the new environment. So it will become complicated. So even better days for the universities, I suppose, and training material. Now, as regards your comment, Federico, I was expecting that the Brussels effect will one way or another come up in a discussion such as that. It is true that, the EU is a regulatory, normative power, a regulatory power, and this has been said through the Brussels effect. Indeed, if it is a three-polar world, then Europe makes the rules, does not have the money, does not have the power. So yes, I very much the actification phenomenon within the EU Brussels effect as a side effect of the Brussels effect. However, if the EU is going to move in this direction, then a couple of considerations should also be taken account. The simplest of which is what happens to the second generation of the AI Act. So we have AI Act 2, we have AI Act 2030 to distinguish from AI Act. So the problems that the Americans, where you are located and you can very well bring in, are facing with their eponymous name-bearing legislation will unavoidably come up also in Europe after 10 or 20 years, when second or third generation of these same instruments that now have first been made eponymous will come up. Now, finally, as regards Clara's question, which is intriguing, it is difficult to say, but new rights, I do not see new rights, I see new schemes and processes. For example, in the AI Act, we suddenly know, we did not know in the past, that AI systems can be high risk or low risk. we must, but now it is set in law. So we have to somehow develop our thought around this once it is settled in law. And maybe new rights will come in this way. But the last time I saw personally, that comes to my mind, the new rights was the GDPR, portability, formal statement of right to be forgotten, but new rights as such, it's difficult to say, but an intriguing question. So thank you. Thank you again for the invitation and the very interesting exchange. Thank you.
Thank you so much, Vagelis. And I think, Clara, now it's your turn. You can also answer your own question. I think that's legitimate, if you wish to.
I won't. Because I really wouldn't know how. I'm just going to take this opportunity to say thank you once again for the invitation. This has been very nice and very interesting, and I'm really glad to have met my colleagues in this panel and to have exchanged with all of you. So thank you so much, and congratulations on the book once again, Edoardo.
Okay, thank you, Clara. Liz.
Hi, and yes, just to echo thanks, Edoardo, this has been really great, and the discussion here has given me food for thought. And I might just quickly conclude by responding, if I may, to Clara's question in connection to what Vagelis said. So if it's not our job to draft new laws, is it our job to draft new rights? The icebreaker I'll be asking my human rights and technology students tomorrow is, does privacy have a different meaning online? And for the last 5 years, my conclusion to that is no, it doesn't. Our fundamental right to privacy exists irrespective of the medium we're exposed to. These days, I'm not so sure. So I don't have an answer, and I'd be interested. Keep in touch, Clara. If you come across anything, let me know.
Okay, thank you so
Thanks,
much,
all.
Liz. And now back to the man of the day, man of the match, Edoardo Celeste. Again, with congratulations for your book. The last word is yours, and I think you should respond and simply wrap up. So I won't speak any further. Thank you very much, Edoardo.
Thank you so much, Federico, and thanks all for your comments and questions. It's impossible actually to address them all in 1 minute. But the final point that I would like to make is a point about gradualism, in the sense that we don't have to imagine that now for example, the emergence of these internet bills of rights represents an attempt to revolutionize the DNA of contemporary constitutionalism. They're certainly one of the sort of like the various pieces of the mosaic, of the puzzle that we are witnessing, that is contributing to a conversation. And this conversation is taking place at different levels. So we have focused today on the internet bills of rights. We have focused on the new acts that are emerging at EU level. But I do think that actually the whole picture that is emerging from the combination of all these various contributions is going in a certain direction. There is an underlying, in my opinion, constitutional discussion. That doesn't necessarily mean making a sort of like tabula rasa of the existing principle and start again. It's also a question of like re-articulation of rights and building on existing rights. I do believe that actually new constitutional provisions can emerge. And I think that also the fact that so many internet bills of rights, and lastly, but certainly not least, the European Commission, the Parliament and the Council, with the adoption of this declaration, the fact that this European declaration has been adopted is also witnesses that not all the players have a clear idea of what is going on in terms of like our digital rights and our constitutional protections in the digital field. So I think that all these discussions are kind of like welcome because they enhance the level of awareness of what our digital rights are. And they also help the legal players actually to sort of like develop their way of interpreting, rethinking, re-articulating existing constitutional rights. So with that, I would like to then to close. It's 3:30 here in Dublin, and I would like to thank again all the panelists Professor Fabbrini, and all the attendees who actually took the time to be with us today. We'll continue with this series of seminars in the coming months, and I look forward, of course, to engaging with you in other conversations related to law and new technologies. So thank you so much.
Thank you very much, Edoardo. Thank you very much, everybody.